Good afternoon and welcome. I'm sorry we're running a little bit late. We wanted to give a little bit of time for the Bork lecture to end before we got it started, and we have a full room to compensate. My name is Alan Dickerson. I'm the chairman of the newly independent Federalist Society Practice Group for Election Law, and it's my privilege to welcome you to our inaugural panel this afternoon on the subject of race and redistricting. How are we to understand the Voting Rights Act? Judge Kenneth Lee has graciously agreed to moderate our discussion this afternoon. Judge Lee has served on the U.S. Court of Appeals for the Ninth Circuit since 2019. He was previously a partner in the law firm of Jenner & Block in Los Angeles, associate counsel to President George W. Bush, and special counsel to Senator Arlen Specter of Pennsylvania, the then chair of the Senate Judiciary Committee. He received his education at Cornell University and Harvard Law School and clerked for Judge Emilia Garzo of the U.S. Court of Appeals for the Fifth Circuit. Your Honor, thank you for joining us. I leave you in our hands.
Great, thank you, Alan. Please continue eating, but lunch will now be served with a side of race, gerrymandering, and voting rights. I think those topics would probably cause heartburn among polite company, but this is FedSoc, so I think this audience will consider this to be an intellectual feast, as the late Judge Robert Bork famously said. As most folks here know, the Section 2 of the Voting Rights Act requires states to consider race in drawing districts, but that is potentially in tension with the Equal Protection Clause of the 14th Amendment. And the Supreme Court just last month in Louisiana v. Callais considered these issues. And today we have an all-star amazing panel who will discuss these issues. I won't read their full bios. You can read them online, but suffice to say, very impressive. To the young folks out there, if your mom looked at their resumes, she'd probably nudge you and say, "Why aren't you doing these things?" Maybe that's just my mom, but sorry, Asian mom joke. Yeah, Tiger Mom, yes. Very briefly, first here to my left is Abi Kambli. He is the Deputy Associate Attorney General at the Department of Justice, where he helps oversee the Civil Rights Division, and he's taken the lead in defending the administration's policies across federal courts. Next, we have Professor Richard Pildes. He is the Sudler Family Professor of Con Law at NYU Law School. He is one of the nation's leading experts in election law. I'm sure you've probably read some of his pieces in New York Times, Washington Post, and the Wall Street Journal. You may have read some of his law review pieces. Most audience, I would say you probably didn't. This audience, you actually probably did read some of his law review pieces. Next, we have Eddie Grime. He's a partner at Graves, Garrett, and Grime. He argued on behalf of the state of Louisiana, the Louisiana v. Callais case that we will be discussing. And finally, we have Professor Derek Muller. He's professor of law at Notre Dame Law School. He's also one of the top election law experts. He's written widely in general publications, law journals, and his own blog. I think it's www.excessofdemocracy.com or org, I'm not sure.
Yeah.
It's a great blog. I'm not getting any referral bonuses or anything, but it is a good blog to read. So we will start with opening statements, 5 to 7 minutes, and then we'll have further discussion. First, Abi.
Well, thank you all for having me. I had to start with the disclaimer that I'm speaking in my personal capacity. My views are my own and don't represent the views of the Department of Justice. So this is a really exciting time when you're talking about VRA and all the other things that happen. And one of my favorite parts of election law in general, and I don't mean this derogatorily, it works so counterintuitively to other areas in law. And what I'm going to focus on is to orient people here, because there might be different levels of understanding as far as what the state of play is, how that fits into the Louisiana v. Callais case, and what litigation on this looks like going forward. So first, the VRA generally, I don't think anyone disputes that the VRA back in the civil rights era was passed for a legitimately good purpose. There was actual discrimination that was happening in a number of states, and it was designed to allow black voters in those states to have equal access to the voting booth. But one of the things that shifted in the early 1980s, there was a Supreme Court case that held that Section 2 of the VRA, which dictates the circumstances under which a majority-minority district might have to be created, was designed to address intentional racial gerrymandering. Well, Congress changed that, and then what spawned immediately thereafter was called the Gingles test. And what the Supreme Court in that case had said is, if these three preconditions are met and the totality of circumstances make it so that a certain minority group has the result of not having equal access to voting, then a majority-minority district would have to be created. So the three preconditions are: you have a minority group that's geographically compact, that's politically cohesive, and that the majority has the ability to block that minority group from selecting the candidate of their choice. So when you go through all that, then you look at the totality of circumstances, and it ends up being a pretty malleable test, as you'll kind of see when we talk about Callais itself. So a few years later, there was this case called Shaw v. Reno that came out, and it was basically a situation where a state was artificially creating a minority district while ignoring all the traditional redistricting principles because of compliance with Section 2 of the VRA. Well, the Supreme Court in that case says you can't racially gerrymander even to comply with the VRA. And if a district is drawn in such a manner that the only conclusion is that racial gerrymandering is what happened, then you have to survive strict scrutiny. So you obviously have a situation where the Equal Protection Clause, which was what the Shaw case was brought under, and the VRA were always going to be in tension. And then in 2023, you have a landmark case called Students for Fair Admission. And one of the things that it stated is that remedies that involve affirmative action or race-based considerations, they can only be designed to fix a particular problem, and they have to have an expiration date. So what you'll see is, in the Louisiana v. Callais case, all three of those principles came to a head, and now the Supreme Court has a vehicle to address that issue. So what happened in Louisiana in that case is Louisiana drew a map that had one majority-minority district, and there was a group of private plaintiffs that sued for them to create a second one, and the district court in that case went through all the different factors and concluded that Louisiana did in fact violate the VRA and ordered it to draw a new map to create that second majority-minority district. Louisiana, what it did was it created its own map to avoid a court-ordered one, and it was a situation where the map in that district spanned 250 miles and covered communities that were pretty far and pretty distinct. But that's what they believed they had to do to comply with the court's order and to protect political incumbents that they wanted to keep in office. And that triggered a challenge from a group of, let's call them non-black plaintiffs, and that's how Callais came into effect. It was effectively an equal protection challenge to how Louisiana drew that map. And Louisiana's defense when it was at the district court was that this is what we had to do to comply with the VRA. So now you have the situation of when can the VRA be a compelling interest to satisfy strict scrutiny when you have a racial gerrymandering claim. So the district court in that case found that Louisiana's second created district, even though court ordered it, was racial gerrymandering. And that's the issue that the Supreme Court is trying to wrestle with. So there's two kind of broad issues that could come out. And if you listen to the Supreme Court's argument, I suspect that they will do something different than keep the current Gingles test as is. And they have a couple ways they can do that. One is they can follow the test set out by the Office of the Solicitor General for the Department of Justice, which advocated in its amicus for a modified Gingles test. So in those first conditions that we mentioned, one of the things that they recommended was that at step one, a VRA plaintiff must not only demonstrate that a second majority minority district can be created, they also have to demonstrate that their map is superior using the state's own race-neutral principles. Then, race must be decoupled from party. So, for instance, you have to demonstrate that, for instance, white Democrats vote differently than black Democrats in order to determine that race is an underlying cause. And then when you get into the totality of circumstances, you have to focus on the factors that illuminate whether states' failure to create the district was objectively likely to reflect intentional discrimination. So it's a much different test than what we currently have with Gingell's. And then there's another option, which is to declare that Section 2 of the VRA's time has passed and it's no longer constitutional, and that's where you get the students for fair admission analysis. So where does that leave the state of play? So right now, I'll kind of describe what it means for states, what it means for plaintiffs seeking VRA majority-minority district, and then what that could mean for plaintiffs that are making Shaw claims or under the Equal Protection Clause. So for states, let's assume that the court utilizes either our tests that the Solicitor General's office or strikes Section 2 of the VRA. It doesn't necessarily mean that every majority-minority district that was created because of the VRA automatically goes away. What it does mean is next time the states can redistrict without having that be something that they are required to take into consideration. But what they do open themselves up to, and what you might see a lot, I suspect, in the future, is more Shaw claims for those previous districts that was designed to comply with Section 2 of the VRA. So what you might see is equal protection claims becoming more frequent. And you already seen this very recently, even before Callais is decided, with the California case that was filed recently. That is effectively a Shaw claim that alleges that California's new Proposition 50 map was racial gerrymandering in violation of the Equal Protection Clause. Now, for VRA plaintiffs, the ones that are seeking a majority-minority district, regardless of the test that the Supreme Court applies, it is going to be more difficult to establish a Section 2 VRA claim. So what you might see more from those types of plaintiffs is when Shaw claims come into effect, especially in states in the South, you might see them intervene to defend the existing maps rather than trying to create additional majority-minority districts. The one party that I didn't mention yet that is kind of in the background of all this is the United States Justice Department, and I'm not going to forecast anything about our strategy, but what I can say is I can say what the current state of the law is. So the current state of the law with the United States is if there's Section 2 claims that are under a modified test, like the ones that we have, if a future Department of Justice ever wanted to bring it, they would face the same restrictions that the private plaintiffs would if our test was adopted. Now, if Section 2 of the VRA goes away altogether, any future Department of Justice would just not have a cause of action under the VRA, as would not a private plaintiff either. But there is a statute called 2000H2 that allows the United States to intervene whenever there's an equal protection claim. So that is something that the law also allows. So when you put all of this together, it's going to lead to a very interesting litigation landscape. And I know a fellow panelist is going to be talking about this, but what's also lurking in the background, assuming Section 2 of the VRA sticks around, is whether a private right of action exists at all under it. For decades, courts have just assumed, without deciding, that the VRA grants a private cause of action. But recently, courts have been questioning that, and the Eighth Circuit in the Turtle Mountain case recently cast doubt on the idea of whether Section 2 allows a private right of action at all. So you have all of that lurking in the background, while at the same time, the future of Section 2 generally is up in the air. So I hope that kind of gives everyone a good lay of the land and what litigation could look like post-Callais.
Great. Thank you. Professor Pildes.
Thank you very much for having me. I'm particularly grateful to be able to try to educate this infant who's with us about the Voting Rights Act. So the VRA is an unusual statute because liability is based on the combination of private action, the way people vote, voting patterns, with state action, the way states design their election districts. And as a result of this, there's always been an underlying tension between two different ways of understanding or thinking about the VRA that's also reflected in doctrine. Sorry, I'm fighting off bronchitis, apparently. And you can also think of this as two different ways of defining the problem to which the VRA is meant to be a solution. So one way is that the statute is essentially viewed as an anti-discrimination statute, that its essential purpose is to make it illegal for states to adopt election structures that reflect a discriminatory purpose. Congress in 1982 decided that because proof of intent was divisive and difficult, it would sort of expand the scope some of what the statute addressed. That's the creation of what's called the results test in Section 2 of the VRA. But still, within this sort of view of the Act, this is because Congress is trying to get at state action that intentionally discriminates on the basis of race or runs a significant risk of doing so. And so that's why the VRA goes beyond just requiring proof of intent to making proof of discriminatory effects or results sufficient. And that's essentially, I think, the view of the statute that the SG took in the Louisiana case. The alternative view of the Act is that it imposes an affirmative obligation on states to counter the effects of private, racially polarized voting patterns among the electorate. So if voting patterns are highly polarized by race, with the result that minority voters are effectively shut out of meaningful political representation, then on this view of the Act, the state has an obligation to design districts in a way that provides meaningful representation to the extent it can do so while still creating reasonably compact, reasonably configured districts. And the second view of the Act was expressed by Justice Jackson in the oral argument. She used an analogy that is somewhat awkward, but I think actually does kind of get at this idea. She compared the Act to the Americans with Disabilities Act, where Congress imposed obligations on states that went beyond merely avoiding intentional discrimination against the disabled. States have to take steps to ensure reasonable accommodations are made to enable people with disabilities to participate kind of more fully in various spheres of life. So it's a kind of an affirmative obligation to make reasonable accommodations. And she referred to the VRA kind of in these terms, and I do think that reflects more this kind of second view of the Act. And under Jingles, the 1986 case that established the current doctrinal framework that's governed since the case was decided, I think the doctrine has reflected more this second view of the Act. So if there is intense racial bloc voting and the candidates minority voters prefer are constantly or consistently defeated, jurisdictions have an obligation to create some appropriate number of reasonably compact districts in which minority voters are viewed as having an equal opportunity to elect their preferred candidates. So that's kind of the underlying tension or different ways of thinking about what the Act is for, what it was designed to do, how to kind of understand its purposes. And with that framework in mind, let me now turn to say a bit about the Louisiana case. So much of the commentary about the case, much of the coverage about the case focused on the idea of race-based districting, whether the court might hold that to be unconstitutional or impose some kind of time limit on race-based districting, maybe akin to Justice O'Connor's approach to affirmative action in the Grutter case. But race-based districting under the VRA only happens at the remedial stage of litigation. Before we get to that stage, the prior question is what constitutes a violation of the VRA in the first place, the liability phase of the case. And that's where these different views of the purposes of the Act kind of come to a head, what should constitute liability in the first place under the VRA? And despite all this commentary about the case in advance that focused so much on race-based districting, the remedial side of the case, I think it's quite plausible that the court might end up focusing more on what constitutes a violation of the VRA in the first place. This is reflected some in Avi's comments. And there were at least three major options presented to the court about how it might reconceptualize what constitutes a violation in the first place under the Act. I'll focus on the one that I think, and I don't want to make any predictions here, but I think the court will be, let's say, at least tempted to go down this path. Maybe it's, I think it's more plausible than some of the other options presented to the court. If there's time, I can maybe say something about those other options. But this option is to redefine what constitutes racially polarized voting. How do we understand when an electorate engages in racially polarized voting? So currently, the way the doctrine works, racial polarization means black and white voters have dramatically different preferences about candidates. And the doctrine doesn't explore anything about the reasons behind those different preferences. It's kind of, in technical terms, it's a simple bivariate regression. Race of candidate, voting support for candidate, race of voters based on precinct level analysis and the like. So if Barack Obama, for example, received 75%, or let's say 85% of the black vote in the state, 25% of the white vote in that state, that would be racially polarized voting under current doctrine. But let's suppose Hillary Clinton or John Kerry got exactly the same white-black vote share in that state when they ran. In that case, voting patterns would appear to reflect partisan political differences between white and black voters rather than something about the race of the candidate. And one of the ways in which circumstances have changed since Congress amended this statute in 1982, and since the court decided this important Jingles case, is that many more white voters who would support Democratic candidates do so now regardless of whether those Democratic candidates are white or black. There are many circumstances that have changed since '82, but this is one of them. So I think the court might be tempted to go down this path. It was suggested by the SG and by some of the other parties in the case, and hold that to prove polarized voting, the plaintiffs have to show that voting patterns reflect something about the race of the candidate rather than different partisan preferences that white and black voters have. So this would navigate the tension, if you will, between these different views of the VRA by, on the one hand, moving the inquiry into voting patterns a bit more in the direction that would be suggestive of racially discriminatory purpose behind voting patterns. That is, if the race of the candidate makes a significant difference in how people vote, maybe that's picking up something that is closer to a kind of discriminatory animus among voters. But at the same time, it would still impose the affirmative obligation on states to counteract that voting pattern, that discriminatory voting pattern, even if the state itself is not intentionally discriminating in the way it designs election districts. So we'd still have this tension within the act. It would be kind of navigated in slightly different terms. Now, how would that change application of the VRA on the ground? I can't say, because I need to see a lot of data on voting patterns in various regions of the country or different parts of the state to get a sense about how much this form of racially polarized voting is or isn't going on. I would say that at the oral argument, counsel for the voting rights plaintiffs for the Legal Defense Fund said that they could show in Louisiana that in fact this kind of voting pattern was going on. So even if the court modified the concept of polarized voting in this way, they believe they would still be able to meet that standard. And if the court does kind of redefine what constitutes liability under the VRA, it might end up not saying anything about the remedial side that has gotten so much attention, about race-based remedial districting as a remedy, what constraints on it might exist, whether there are any limits on it. The court could easily remand this case to the lower courts to reassess whether there were Voting Rights Act violations for which any remedy was necessary. So lots more we can say, I'm sure we will say about these issues, but that's one way of understanding not just the case itself, but the kind of historical tensions within the Act and different ways of thinking about it that you can see reflected in the various arguments before the court.
Great. Thank you.
Well, those were very interesting comments. One thing I want to make clear at the outset is I represented the voters. We were the ones who brought the lawsuit, and so we were actually against Louisiana, but then they came over to our side. In fact, I have reason to believe that the state of Louisiana has salted the audience here today with some lawyers to give me some hard questions. But no, I was joking. But we were united at the re-argument phase here. So I kind of had a presentation I was going to walk through, but I think I'd rather maybe just respond to the first couple of sets of comments and try to maybe this will lead to a better understanding of where the court could end up. One thing I want to highlight is kind of the nuts and bolts of a Shaw v. Reno claim, a racial gerrymandering claim. And one question that came up a little bit at the oral argument is, what is the injury? So, when someone brings a Shaw claim, what are they saying about the plaintiffs, the voters? And the court has been clear. There's a very specific type of injury that was controversial at first. It took 2 or 3 cases before the dissenters in the Shaw line of cases stopped raising this. But the injury is really racial stereotyping. It's the idea that individual voters have been placed in a district based on assumptions about the way they think and the way they approach the world and then the way they vote. And again, based solely on their race. So it's the sort of stereotyping injury. And then there are some other injuries that flow from that. There's sort of a stigmatizing injury, and then there's a representational injury that whoever is elected from this district will be presumed to be representing this district specially created with a certain racial component based on the assumption that that people of a certain race want certain things. And so, that kind of thinking, the court has been clear from the very start, undermines the entire idea of our democracy. And so that's the injury here. You might hear about vote dilution or about cracking and packing and things like that. Those are different injuries that you would bring under a sort of a different theory. And so, and in fact, we'll get to in a second, that's really the Voting Rights Act cases that we see with single-member districts are usually raising that kind of a theory. That's the injury that they say has occurred. But I want to give you just a couple of quotes from Shaw just to drive this point home. One quote that gets cited from Shaw and then in all the other cases: racial classifications are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. There's one. A redistricting plan that includes people of one race who, quote, are otherwise widely separated by geographical and political boundaries and who may have little in common but the color of their skin, bears an uncomfortable resemblance to political apartheid. Another one, racial gerrymanders, quote, balkanize us into competing political factions. And then finally, and I think this is sort of captures the spirit of all this area of law, racial gerrymanders carry us, quote, further from the goal of a political system in which race no longer matters. And so that's the spirit of our claim, and that's the spirit of, I think, of continuing racial gerrymandering claims that will be brought going forward. Now, how does the VRA get involved here in two ways? One, people might just bring a Section 2 claim, and you heard Abi kind of go through the background history. There was a freestanding Section 2 claim brought before we brought our case. And so there are lots of just plain old Section 2 cases. Second, Section 2 is cited by states to satisfy strict scrutiny when they are faced with a racial gerrymandering claim. And that's, this was a racial gerrymandering case. Why did we spend all of re-argument talking about Section 2? Well, it's because the state said that's our compelling interest, is complying with the Voting Rights Act. And I think at this point, I want to kind of turn to the two different theories of Section 2 that Professor Pillis just kind of mentioned. It's interesting. So he labeled two. He said, one, it's an anti-discrimination statute. That's what we talked about at oral argument almost entirely. That's what was heavily briefed. Then he said, second, it counters the effects of private acts that end up having the effect of sort of canceling out or depriving a racial group of the effectiveness of their votes. And it's funny, I thought about this while he was talking, and this came up, I think, a little bit in prep. If you look at the Senate report that everybody cites to talk about the legislative purpose behind Section 2, the Senate report tries to make a case under the first theory. It basically says, look, we know there's this Mobile versus Bolden case. It requires, the 15th Amendment, bringing a claim there requires intent. Section 2 requires intent. And Congress said, yeah, but as we look at the cases, there's all kinds of reasons why we don't want litigants focusing on that issue. In fact, it said courts are asking the wrong question. And you could also read the Senate report as just disagreeing with the Supreme Court, which would be a problem. But that's kind of so theory one of Section 2 is kind of what the Senate report reads like. But then when you look at the factors that they say litigants will need to prove in a Section 2 case, it does look a little bit more like the second theory. And so you meet these three preconditions, which unfortunately is often determinative. It's not supposed to be in Section 2 cases. You look at the 10 Senate factors that people choose, that people have to satisfy, and they're non-exclusive. Some of those do look a little bit like intent. And whose intent? So we have to have state action, of course, okay? And so one question might be, well, why do we care about the effects of private acts? And we didn't explore this at all in the case, but what you could say is if there is, and I'm not saying I agree with this, but this is the best I think I can do, is if there is a bunch of private intentional discrimination, private discrimination based on race, people will not vote for a candidate because of the candidate's race. And that's widespread somewhere. And the state is aware of that and then draws districts knowing that a certain impact will occur because of the private intentional discrimination. Maybe that could sustain the second theory. I don't know that I agree with that, but interestingly, if you look at the Senate factors, it could lead there. That's not how courts have been applying Section 2. But in the Jingles case itself, there's an interesting discussion that goes on for many pages. Justice Brennan only had a plurality in Jingles on an important point, which was, does the race of, when we're measuring racially polarized voting, does the race of the candidate matter? And Justice Brennan said, well, no, it doesn't. And to explain that further, I'd have to go beyond my allotted time here. But basically says it doesn't matter. What we're just trying to show is that if you run this bivariate, regression analysis, that black voters vote for one person and white voters vote for another, and exactly the race of that person doesn't matter. Well, Justice White in his concurrence, and then Justice O'Connor in her concurrence and dissent, I think. Now I'm forgetting that part of it. I think there's 5 votes for the argument that the race of the candidate does matter, because that's how you know whether let's say, the white majority is actually voting against the candidate because the candidate's black. And that's how you would actually find racial discrimination instead of just black and white voters politically want different people. And so this kind of goes into the test, what could result in terms of what the liability test would be. One major point that was raised in our brief and then also in the SG's brief is, if you have to show racially polarized voting under Section 2, it needs to be true racially polarized voting. In other words, the voters themselves, at minimum, have to be voting for or against candidates based on those candidates' race. And there are ways of doing it. Now, I did hear the LDF at the argument say, well, we can prove that in Louisiana. I don't know about that. I'd like to see that. I don't think they can, and I think a lot of people would say, well, that requirement right there may doom modern-day Section 2 claims. There are several other issues there as well. There are several other ways you could tighten the screws on Section 2 claims. Very briefly, but our view in our brief was, SFFA is a rich opinion full of principles that apply all across the 14th Amendment space, and the doctrines all kind of coming together. And, we believe that if the remedy requires racial stereotyping, that sets this apart from the ADA or other cases where ramps and other things that you have to build, you're not stereotyping anyone as part of the remedy. And that's what happens here. So if we're going to do that under the 14th Amendment, you better have just had intentional discrimination, and you better be trying to unwind it. And it needs to happen quickly and be targeted to that discrimination and then go away. And the problem is Section 2, there's just no way of reading it that really does that, and that's why our position is Section 2 should not be used to satisfy strict scrutiny. People can still bring voter dilution claims directly under the 15th Amendment. It can still be done. So there's plenty of constitutional claims out there still, just don't use Section 2. So maybe I went too long, but that's our view. Thank you.
Great, thank you.
Well, thank you. I appreciate all those views on Callais, although I'm on record for those of you who listen to Sarah Isker's podcast that I have no idea what's going to happen in this case. So there's a lot of options that were available that I think Professor Pildes nicely laid out, and especially different ways the court can go. But one of the other pressing and very different issues is a cert petition pending in front of the Supreme Court right now about even the availability of private litigants to show up and bring these Section 2 claims, or not these Section 2 claims, but Section 2 claims in the first place. And that relates to private rights of action under the Voting Rights Act. Increasingly, election law is not just about constitutional law or statutory rules like the Voting Rights Act. It's increasingly federal courts doctrine. A lot of our standing cases are increasingly election law cases, and now this is a pressing issue as we think about private rights of action. But rights of action we think about when Congress passes statutes. It also includes the rules for deciding how we go about enforcing those statutes. So it doesn't just pass statutes in a vacuum. It thinks sometimes it wants the president to enforce these laws. Sometimes it wants an agency to develop rules and then follow through and enforce the rules that it provides. Sometimes it wants the Attorney General to bring lawsuits on behalf of the United States for violations. And sometimes it wants private litigants to be able to go out there and find violations and sue on their own behalf as an injury and be able to get redress. And in these kinds of cases, injunctive relief. So there's a wide body of doctrine thinking about this. There's obviously some statutes that quite explicitly allow for private litigants to sue. The question is, what happens if we don't have that explicit language somewhere in the statute? For a time, it started in the 1920s, although really it reached its peak in the 1960s. The Supreme Court was implying private rights of action in federal statutes. It would look at a statute, it would say, well, this seems like a benefit to the public. It seems like this would benefit private individuals. Congress wants to help these individuals. The best way for these individuals to get help is to be able to go into court and sue and to be able to seek relief as the judiciary deems appropriate. And so we can fashion relief, whether it's monetary damages, whether it's injunctive relief, whatever it might be. So that was kind of in its heyday in the 1960s, sort of this opportunity for the judiciary to, depending on your view, kind of independently develop remedies or to come alongside Congress and fill out the scheme of the statute as Congress would have otherwise intended. By the 1980s, the court became more skeptical of this. In 2001, Justice Scalia in Alexander versus Sandoval wrote an opinion essentially saying this is going to be very difficult to show. We want to look at the text of statutes. We read the text of statutes. The text of statutes will tell us whether there's a private right of action and whether or not we ought to imply one. And usually if you don't see that in the text of the statute, that is, if there's not an explicit rights-creating language with relief made available to litigants, we are not going to jump in and imply a remedy. So other litigants turned around and said, well, we've got this statute called Section 1983, which allows for litigants to come into court and sue for monetary damages and other kinds of appropriate relief when there's a violation of the Constitution and laws of the United States. And for a period of time, the Supreme Court in the 1980s was saying, yeah, it says laws of the United States, come on in, bring lawsuits relating to the laws of the United States. And in 2002, the Supreme Court in a case called Gonzaga versus Doe says, well, hold on a second. When we say laws of the United States, we think about those rights set up by the laws of the United States. It means rights created by statutes. And just like we said in Alexander versus Sandoval, we need to see this rights-creating language in the statute before you can use 1983 as the vehicle to bring these kinds of claims. Okay, so that's sort of the background of that implied right of action, or thinking about 1983 as the vehicle. So we have Section 2 of the Voting Rights Act. And the Voting Rights Act has a number of provisions, it's been amended over the years. It explicitly allows the Attorney General to come into court and sue. It explicitly allows private litigants in certain circumstances to come in and sue. But then we have Section 2 of the Voting Rights Act. And in 1980, the Supreme Court in Mobile versus Bolden sort of looks at Section 2 with this claim and says, well, we sort of have assumed that you can bring a private right of action under the Act, see what we've allowed litigants to do under Section 5. And then several years later, 1995, the Supreme Court, in a case called Morse, was construing Section 10 of the Voting Rights Act and says, well, we've always kind of assumed that you could bring it under Section 2, and likewise here, you're able to bring a claim under Section 10 of the Act. Again, not really explicitly making his finding, but sort of making an assumption. And in 2021, Justices Gorsuch and Thomas wrote separately in a decision called Brnovich versus Democratic National Committee, and they said, by the way, this is a Section 2 case, but we've never really found that there's an explicit private right of action under Section 2. We would be opening to revisiting this. And that immediately gets a lot of litigants out there to say, oh, well, we've got 2 votes. Can we find 3 more? And there are additional challenges now, sort of when private litigants show up bringing these Section 2 claims, to resist their ability to do so. So a decision out of the 8th Circuit called Arkansas State Conference of the NAACP in 2023, Judge Strauss, in an opinion for the 8th Circuit, said, we read the text. While Section 2A talks about the right to vote, Section 2B is not really an individual right. It's unclear. It seems more like a collective right of groups of racial minorities to be able to elect the preferred candidates of their choice. It's ambiguous whether or not there's this right. And as a result, we can't say with certainty that there is this right there, but certainly there's no remedy built into the statute. So the litigants came back in a case called Turtle Mountain Band, in a different case, or a different set of litigants, into the 8th Circuit, saying, well, we want to use 1983. And an opinion by Judge Grunder, my former boss, who I believe is in the room, would say, no, we looked at this, we can't find anything that speaks in that explicit, unambiguous rights-creating language. That's the language from cases like Alexander and Gonzaga. So that petition is now pending in front of the Supreme Court. And I sort of want to make two final points as we think about what might, well, maybe 3. The first is that I think this is going to remain pending until this case is resolved, because if something really dramatic happens with Section 2, in the unlikely event it's found unconstitutional constitutional that might moot some of these concerns. The second is that the Supreme Court has, in a series of other recent cases, really doubled down on this reluctance to imply private rights of action or rights-creating language into statutes. Now, a couple of terms ago in a case called Talevsky, the Supreme Court found one in one of these spending clause cases where you were trying to seek compensation for money that the state was supposed to spend. Private litigants showed up. And Justice Barrett and Gorsuch kind of wrote separately to say, while we're joining the plaintiffs here, we're really skeptical that this is going to extend into future cases. And sure enough, last term in Medina, the Supreme Court said, we're not going to extend this in an additional case. So it's become increasingly difficult to bring these kinds of claims under Section 1983. I think the reason that the Supreme Court is going to be increasingly skeptical in the event that it does bring, in the event that it does hear this case. But the final point is to say it's not that these cases can't be brought, it's just they can't be brought by private litigants. And so this puts really all of the pressure on the Department of Justice in its enforcement authority to decide what kinds of cases it is going to bring and to develop the legal strategy and theory about what jurisdictions really merit this and where the places that these actions ought to be brought. So it would change the nature of litigation and move it out of the hands of sort of private litigants around the country roaming around and deciding to litigate and instead into the hands of the Department of Justice.
Great. Great. Thank you to all the panelists for the informative analysis. I've one question that I want to raise is the Supreme Court in recent years has suggested perhaps that it's time to move beyond race. I think in Shelby County, the Chief Justice, said things have gotten better in terms of voting preclearance. And Professor Pildes, you mentioned Justice O'Connor's opinion in Grutter, saying maybe affirmative action should end in 25 years. And during oral argument in Callais, Justice Kavanaugh touched upon this theme and says, should there be a time limit for Section 2? I know Justice Kavanaugh was here last night. I don't think he's here, so if the panelists want to offer your candid assessment of that, and if you're leery of that, if you want to respond to other panelist member, you're free to do so.
I'm happy to say a little bit about that. So I'm a little bit puzzled by that idea for the following reason. Let's say Section 2 of the Voting Rights Act really was confined to prohibiting intentional discrimination in the design of election districts. I don't think anyone would think there would have to be some constitutional time limit on that or on remedies for that. So it seems to me the question that Justice Kavanaugh is trying to get at in this other way is really the question of what does the Voting Rights Act prohibit, or what should it prohibit, or what can it prohibit? But whenever that's resolved, then the remedies that follow from that definition of what is illegal in the way districts are designed would seem to me to be, I don't see why it would be time limited. So I think Justice Kavanaugh is gesturing at the idea that circumstances have changed since 1982 when Congress enacted this results test, and they have in certain ways. And the question, I think the right question is, should the application of the VRA in terms of what makes the state liable, in what ways, if any, should it change to reflect those changes? But once that's resolved, then I don't see why there'd be a time limit on the remedies that would follow from it. So maybe I'm misunderstanding something about what he's getting at, but that's why I found, that's how I would locate where his comments actually seem to me to make most sense to focus on what should be liability under the Act, not so much about remedies.
So this is what we asked ourselves on re-argument, because this is in his concurrence, Justice Kavanaugh's concurrence in the Allen v. Milligan. He says no one presented the so-called temporal argument. Now, we looked very carefully to see what Alabama did argue in Allen v. Milligan, and they came pretty close. I mean, they raised some constitutional arguments. It really wasn't the main thrust of their position there, but they preserved them. They were in the briefs. And Justice Kavanaugh was trying to point out that nobody quite raised that. And he cites to part of Justice Thomas's dissent in Allen v. Milligan. And if you go to the section he cites, that's the part of the dissent where Justice Thomas is sort of talking about a couple of earlier cases, City of Rome and South Carolina versus Katzenbach, which really have come to stand, I think, for a kind of congruence and proportionality review. And so what that lends itself, I'm going to end up where Professor Pildes is, I think, but where that takes you is, what's the bubble in Section 2? What's the prophylactic element of Section 2 that goes beyond the 15th Amendment itself? And so going back to the kind of useful two different ways of looking at Section 2, looking at it as an anti-discrimination statute, an enforcement statute under the 15th Amendment, the bubble would be, well, we think that we're not catching all the intentional discrimination out there with a test for intentional discrimination, so we need to reach out to cover other things that themselves are not discrimination. And so that's what some of the earlier VRA cases were about, getting rid of literacy tests or things like that in theory were not intentionally discriminatory, but maybe were applied that way. The court said you can reach conduct that's not intentional discrimination if you've just had intentional discrimination and people were using these same things. So I think where he was going is maybe there was a time where you could have this prophylactic bubble. Let's say even in 1982, when it was amended, you could have gone and reached other conduct that wasn't intentional discrimination. But we don't have the situation in America today that we had in 1982. Therefore, we don't need that prophylaxis anymore. So that would be the quote temporal argument. It's not that the remedies are limited. It's that we don't need to reach out and engage in race-based remedies anymore because we don't have the underlying discrimination in America.
Yeah, and one thing that I would just add to this, part of the tension that's also out there is how much of this is what Section 2 of the VRA requires versus how courts have been applying the Gingell's test, because part of the issue is Gingell's can be very malleable, and as Eddie was saying, sometimes courts stop at the preconditions and don't really get into the remaining conditions. And part of the Solicitor General's office position was there is a way to read the VRA that's constitutional, and if you modify the Gingell's test, you can get there. So that's also something that's out there when you're also, before we even think about, is it time limited? Maybe the first question should also be, is there a way to read the VRA in a constitutional manner that separates it from how courts have been historically applying it?
Okay. I know we started late, and I want to give the audience an opportunity to ask questions, but before that, does anyone else want to respond to any other comments from the presentations?
I think, one point to raise is I think there have been some questions raised about what this case might do to redistricting long term, but the immediacy is people thinking about 2026. And my sense is the court's not going to issue a decision until May or June. That in most jurisdictions means the primary elections have already been held for congressional districts in 2026. The Supreme Court, the federal courts have made it clear that you can't alter the rules on the eve of an election to the extent that it would sow voter confusion or create administrative complications in elections, from a case called Purcell versus Gonzalez in 2006. And so if the court comes out with a decision in May or June, it could, at the margins in a couple of jurisdictions that have very late primaries in August or September, you might see attempted litigation or efforts by some state legislatures to move things around. But my sense is that the effects are going to be pretty muted in the event that there is some change, to the extent it's a measurable or meaningful change in a lot of jurisdictions. I know that Louisiana has moved some of its deadlines, anticipating that the case might come down at some point, and thinking about whether they can be responsive to it. Again, it's not clear what the timing is, but I think its effects for 2026 are probably going to be fairly muted. The effects will be in 2028 or beyond.
Okay. All right, great. Well, thank you to our panelists for their presentation. Now we will let the audience member ask a question, and to paraphrase Alex Trebek, please let it be in the form of a question. Gentleman over there, if you want to go first.
Me?
Yes.
Very good panel, thank you. question I have is, has the Voting Rights Act gone on a life of its own? It's kind of, it seems like it's a lot of control. Over the past hour, I've only heard the 15th Amendment mentioned twice. My understanding is that the Voting Rights Act was authorized by Section 2 of the 15th Amendment to enforce Section 1 of the 15th Amendment. Why are we talking about polarized voting? I mean, Democrats, Republicans are polarized voting as well. So it seems to me that today blacks can vote. I don't think there's one thing that blacks aren't able to vote, so should we just declare victory and go home? So has the Voting Rights Act gone on a life of its own, and two, why are we talking about polarized voting?
Do you want to answer?
You can start.
Okay. So the Supreme Court had held that the 14th and 15th Amendments themselves prohibit unconstitutional racial vote dilution. So even if everybody can, freely vote and the like, the court recognized as a matter of constitutional law in the 1970s that election structures can violate the Constitution to the extent that they have this exclusionary effect. Let me kind of just put it this way, if I can. Think about this at the time the doctrines are being formed. You have areas of the South that may have a black population of a third, like the city of Mobile versus Alabama case. They've never elected a candidate that the black community in Mobile supports to the county commission because there's very significant white bloc or white and black bloc voting. The theory of democracy this takes it to a high level, but presumes that groups will win or lose at various points in the democratic process. If you don't win all the time, but you can win the next time. If you have a locked up political structure in which a minority group is consistently unable to get any candidates elected, this, in the view of the court, is a problem for democracy. It becomes a constitutional violation. So when Congress enacts the Voting Rights Act amendments in 1982, it's reflecting the constitutional doctrine that vote dilution can be unconstitutional. Then there's a debate about exactly how you identify vote dilution and how far the statute can go in enforcing the 15th Amendment. But I mean, that's the basic concept, that there's something defective in a democratic political system in which identifiable minorities are consistently, time after time after time, shut out of meaningful representation because of these locked-in voting patterns. You could agree or disagree with that, but that's the constitutional basis for Section 2.
Yeah, and even without the Voting Rights Act, you would have people bringing vote dilution claims directly under the 14th, 15th Amendment if they wanted to. I mean, there's entire string of precedent that could go to that. I mean, I think this came up a little bit in Allen v. Milligan. I mean, Alabama said, well, don't we need a benchmark about what your undiluted voting strength should be? And there's a pedigree for that in the case law, but the court, declined to create a benchmark test along with Section 2. But I think that's very much a question about voter dilution claims that has never really been resolved.
May I follow up?
A quick follow-up, sure.
Yeah. It seems that's kind of just made up. Where in the Constitution does it talk about vote dilution? I mean, if there's an actual injury, I mean, if you always in the South in the county or wherever you elect a white candidate and blacks are being killed, I mean, something like, I mean, you have to actually don't say that there's actual injury. The fact that there's a white person who wins is not de facto a problem. So I just don't see that. I mean, democracy is not perfect, is what I'm saying. So it's just, I don't know how we're going to perfect it.
Well, yeah, so suppose the state of Louisiana says, we're going to design our election districts so that we intentionally make it clear that black voters, as long as there's these polarized voting patterns, are not going to be able to ever elect anybody to Congress or the state legislature or the county commission. Because we know these are the voting patterns. We can design the election districts so that Those voters will always be a minority in any district we design. Should that be unconstitutional? The Supreme Court has said yes, as a matter of constitutional doctrine. And then Congress followed up with the statute, which raises its own set of questions. But that's kind of the core understanding.
Thank you.
Yeah.
Thank you.
Good afternoon. Thank you all very much for a wonderful, wonderful panel. My question relates to Section 2B of the Voting Rights Act, which has language that's taken from White versus Register, one of the cases that I think you were referring to. But the court in Jingles didn't say that the meaning of Section 2B is the same as what the court was talking about in White versus Register. It instead added this, the preconditions analysis in Jingles. So my question is, if the court now says that Justice O'Connor was right in Jingles in saying that the amendments to Section 2 of the Voting Rights Act really just meant to reinstate White versus Register, how does that fit into the two models of conceptualizing the Voting Rights Act, and how does it affect the rest of the questions in the case?
I think that's the problem with, I think that's one of the problems with trying to argue that all we're doing, I mean, I would make this argument if I had to, but I think saying that all we're doing is resolving some unanswered questions in Jingles and then we move on, I'm not sure that that gets it done. And so I don't know if I'm answering your question, but I don't think we can understand Justice O'Connor's concurrence as really, I hate to say this, as really being an open option, because I think that's not how anyone's viewed Jingles since then. I mean, technically it may be open to do that, but I don't love that as a way to address this issue.
I think the way I'd respond quickly is Congress did not have a clear concept of vote dilution in mind when it enacted the 1982 amendments. It generated a lot of factors for courts to consider. And then what the Supreme Court did in Jingles is what the courts often do. It kind of distilled those down to create a standard or an approach that the courts viewed as ones they could administer in a kind of somewhat consistent way. So whether you agree with that or not, I mean, I think that's how we got Jingles. Congress threw a big bunch of things at the courts, and the Supreme Court said, we're going to distill this down to a few more manageable criteria for enforceability. And that's what's created the regime we've had kind of ever since. And as Abhi said, I think the courts have de-emphasized the various other factors that Congress identified beyond these kind of three key variables that Jingles made front and center.
Thank you very much.
Thank you. I think one last question here.
So most of the discussion seems to be on the black-white framework with African Americans and white voters, but the Supreme Court has interpreted the VRA to include other minority groups, and in Texas, which is where I litigated for the last 6 years, that's actually a big issue because the largest ethnic group, period, is Hispanics, larger than whites, and you have sizable black and Asian populations that are within the state. And so I guess my question for you is, how does that play into the temporal period for the VRA when the VRA was enacted at a time where whites were maybe 85% of the population in the United States, and now you have states like Texas that are minority majority, and it's much more complicated to create either a minority majority district for one, or where you might even see whites as a minority in certain parts of the state.
Yeah, I can take a stab at that a little bit, but yes, really, Latino districts, especially in Texas, present a problem even applying Jingles as it is, because some of the preconditions is that they have to be compact and politically cohesive. I remember one exit poll that I saw at the end of 2024, 60% of Texas Latinos voted Republican. So at that point, at best, you have a minority group that's evenly divided. So yes, when you try to extend the Jingles framework beyond the South and beyond African American and white voting patterns, it's going to create issues. And I do think that when the Supreme Court answers the question in Callais v. Louisiana, I think that'll in some ways shape how majority Latino districts, to the extent that states want to create them, will be decided as well.
Yeah, this is one of the many ways the VRA has changed since the framework was created in the 80s. And you sometimes have cases in which there are conflicts between black voters and Hispanic voters over how districts are to be designed. That's something that didn't exist, in the 80s when these cases were created. But as Avi was saying, because the Hispanic community is so heterogeneous in various ways, and voting patterns in the Hispanic community are maybe becoming less polarized. The way the act applies to Hispanic voters may be changing very rapidly right now, and Texas will test that.
Thank you.
Okay. Before we adjourn, I was given an announcement to make. Everyone here is getting a free car. Just getting no Oprah moment, but almost as good as Deputy Attorney General Todd Blanche will have a fireside chat at the International Ballroom at 2 p.m. And again, I want to thank the panelists here for their excellent analysis.